Good morning, everybody. I'm your host, the Supreme Litigant, and I'm back again with another video. This video right here that I uploaded last night, apparently, it's helping some people, so that's very good. If it's not helping you, let me know, okay, and let me know, what can I do to better explain to you what you're actually doing, okay. I'm going to go to my response, because these, in my case, this is my response. This response is not on the court's docket, just to let y'all know, because we had settled the case, so I just didn't even file it. But anyway, they had filed a motion for summary judgment, and I started drafting my response to their motion for summary judgment, because I'm gonna win. I know I'm gonna win. If this judge treats me fairly, I'm gonna win. But anyway, um sorry about that. This damn phone is going off. Anyway, I'm gonna read y'all my response to their summary judgment, and I'm gonna read you their facts and what they're arguing, and then I'm gonna read you my facts and what I'm arguing. I'm gonna show y'all uh, the conclusions, the reasonable conclusions that I had based on the facts of the case, of what I already knew. So we'll start it off like this. Defendants contend, meaning that they're arguing, that they allegedly had probable cause to arrest plaintiff pursuant to Section 3269 of the Code Alabama 1975, because plaintiff refused to provide identification when requested, and therefore allegedly exercised their discretionary function when arresting and detaining plaintiff, which allegedly entitles them to qualified immunity as a matter of law. Plaintiff disputes those contentions to the extent that they separately or collectively imply plaintiff was lawfully required to comply with defendant's prima facie request during a prima facie consensual encounter where defendants violated clearly established law of which a reasonable officer would have known. Moreover, Section 3269 of the Code Alabama 1975 does not and cannot lawfully give police officers carte blanche. Y'all need to look that word up if y'all don't know what that means. But it means unrestricted authority or something like that. Uh, what is it? What is it? Does not and cannot lawfully give police officers carte blanche to arrest and detain for refusal to obey any demand that they may choose to direct at plaintiff. And there's a footnote right there. That footnote, if you scroll down, there's going to be a case in support of that argument of what I just said. Plaintiff's only duty is to comply with lawful orders. See, look, man, I know my rights because I read cases. I don't care what no fucking statutes say, because statutes are not laws. I read case law. I go straight to the common law, which is judge-made law, which is the common law of the judiciary, and I read cases. That is where your rights are being declared at. If you go and read cases, those cases are going to tell you, like, for example, if you want to sue somebody for malicious prosecution, do you need to go and read cases? And in those cases, the common law cases, they're gonna tell you what your elements are that you need to have in your complaint for a valid cause of action called malicious prosecution. Or if you wanted to sue somebody for violating your Fourth Amendment, let's say they unlawfully arrested you, then you need to go and read cases. Okay, those cases are going to tell you what facts that you need to allege. They're not going to tell you which facts, but they're gonna give you an idea of what you need to allege in the complaint to have a valid cause of action for a violation of the Fourth Amendment for being unlawfully arrested. That's why I always read cases. I don't care what no statutes say. A very thoroughly plaintiff, an objectively reasonable person. Y'all gonna see that everywhere. Matter of fact, y'all need to understand what a reasonable person is. Basically, a reasonable person is this: it's a woman or man who only acts. Let me rephrase that: who only reacts to a situation based on the facts and circumstances of that situation. So, for example, let's say you're traveling down the road. Um, there's a hole in the road. Okay, would a reasonable person keep driving? Or let me rephrase that. Keep traveling, keep traveling, and just keep traveling until they hit that hole and their car falls in the hole, or they break their tire or something like that. No. Once a reasonable person sees that, a reasonable person would check all of their rearview mirrors, turn on their signal light, and merge over to avoid the hazard that's in the street. Okay, you would be a reason. That would be a reasonable thing to do. Do y'all see what I'm saying? Based on the facts and circumstances, that's what a reasonable person is, and that's just one example. Anyway, a very thoroughly plaintiff and objectively reasonable person asked Breland a reasonable question, to which Breland replied, "Because you're broke down in the middle of my highway, and I don't know who you are, or I just want to know who I'm talking to." That's what he said to me. Now, I didn't say this in the complaint initially, because I didn't think it was relevant. But I just this time, in my reply to that motion for summary judgment, I just went head on and said, anyway, after witnessing these exculpatory answers of Breland, y'all need to go and read that word. I mean, y'all need to go and look that word up, by the way, because this basically means that this his answer proved that I was innocent of doing anything. So go look that up. After witnessing these exculpatory answers of Breland, plaintiff then reasonably concluded, as any other reasonable person would have, that he was not lawfully required to comply with defendant's prima facie request. Defendants had no authority to enforce neither the provisions of that statute nor any other statute, because no offense was ever committed. But had that offense alleged by defendants been committed, plaintiff would have simply complied, because then defendants would have issued two lawful orders, which, if either then refused by plaintiff, would warrant a reasonable officer to believe plaintiff committed an offense in their presence, thus making the arrest and detention of plaintiff lawful, which would then immunize defendants from suit. In other words, they would get immunity from this lawsuit. Y'all see this? And I have footnotes in here, supporting why I'm saying what I'm saying. This footnote right here is plaintiff knows when he is given a lawful order and an unlawful order. I know this shit. It's based on the facts and circumstances of the case. Let me go to number 12. When I was telling you, this section right here cannot lawfully give police officers carte blanche to arrest and detain for refusal to obey any demand that they may choose to direct at plaintiff. And here's the footnote right here that says that. It's right here. A police officer cannot give an unlawful order and then base probable cause for an arrest on a citizen's refusal to obey that unlawful order. That is clearly established law. That shit is so, you don't even, like, it don't even need to be a case on this for that shit to be, for that to be known. Because a reasonable officer would know that. All of the judges know this stuff. So we're going to scroll down some more. Scroll down a little bit more. Plaintiff, let me make this. Can I make this bigger? Yeah, I want y'all to see this. Sorry, it was so small the first time, y'all. Plaintiff avers that he was undoubtedly a stranded motorist, and that this was a consensual encounter. And during consensual encounters, plaintiff may either voluntarily comply with defendant's requests or choose to ignore them, because the Fourth Amendment's mandate of either reasonable suspicion or probable cause is not required. And I have a footnote right there from a United States Supreme Court case, so it's going to be from the 11th Circuit, supporting why I'm saying what I'm saying. Because plaintiff was free to decline the officer's request or otherwise terminate the encounter, which plaintiff attempted to do twice, emphasis added, prior to defendant's unlawful actions. In fact, the only reason plaintiff refused to comply with the two requests of defendants is simply because plaintiff did not have to, since being a stranded motorist is neither an offense in Alabama, nor is refusing to provide identification during consensual encounters in Alabama, emphasis added. And I have footnotes, just I know all of this stuff. And I cite all of the case law supporting my contention, all of them. For defendants to be entitled to qualified immunity, Actual probable cause, remember when I told y'all that? Actual probable cause is irrelevant since the proper standard is arguable probable cause. Arguable probable cause is going to determine if they acted reasonably under the facts and circumstances. Arguable probable cause exists when an officer reasonably could have believed that probable cause existed in light of the information the officer possessed. Scroll down a little bit more. As we frame the concept in Lee versus Ferrero, arguable probable cause exists where reasonable officers in the same circumstances and possessing the same knowledge as the defendant, in other words, the real officer, as the defendant, could have believed that probable cause existed. In determining whether arguable probable cause exists, we apply an objective standard asking whether the officer's actions are objectively reasonable, regardless of the officer's underlying intent or motivation. So here are the facts of the case. Notice I'm talking about facts, the facts and circumstances of the case, because they are going to determine if this officer acted reasonably. If this officer acted reasonably under the facts and circumstances of this case, even if they made a mistake of law, they are going to get immunity. Y'all need to understand that. Because the Fourth Amendment only prohibits unreasonable searches and seizures. The only facts Breland knew of after he arrived on the scene was that plaintiff was tired, mentally exhausted, his car had recently broken down, and plaintiff's name was Isaac. That's the only thing he knew. It's the only thing that man knew. Holyfield and Morgan did not know any of the facts whatsoever about the incident until after they, along with Breland, arrested and detained plaintiff. The fact that plaintiff refused to provide Breland his identification, was frustrated and mentally exhausted, is not per se criminal activity or an indication thereof. This was a prima facie consensual encounter that defendants knew or should have known since a holding of when a let me rephrase that. Defendants knew or should have known since a holding of when the Fourth Amendment's mandate of probable cause and reasonable suspicion apply is, in fact, clearly established law of which a reasonable officer would have known. And it is. A reasonable officer would know this. Thus, reasonable officers confronted with these same facts and circumstances as the defendants would not have believed that probable cause existed to arrest plaintiff, and therefore, as a matter of law, defendants are not entitled to qualified immunity as to plaintiff's first cause of action, nor as to plaintiff's second cause of action. What is this? How much time we on? We on 13 minutes. I'm gonna go a little bit longer. Yeah, we'll do this. Plaintiff avers that the Fourth Amendment of the United States Constitution and Article 1, Section 5 of the Alabama Constitution, 1901, are substantially the same because both provisions are interpreted the same. And then there's a case right there that supports that contention. Anyway, let's see. Article 1, Section 5, Alabama Constitution of 1901 states that the same fundamental principle as thus federal case law interpreting the Fourth Amendment applies. In considering this, plaintiff incorporates his first argument in opposition to defendant's first claim as claim of qualified immunity as to plaintiff's first cause of action to defendant's second claim of qualified immunity as to plaintiff's second cause of action. Sorry, that might have been confusing for y'all. I'm sorry, y'all. But you get what I'm saying. So we're going to stop right there. And we're going to give y'all, I'm just going to give y'all some examples and just ask y'all some questions. Would a reasonable officer walk up to you, pull out his taser, and shoot you with it without any facts justifying why she or he shot you? Would a reasonable officer do that? No, because a reasonable officer either knows or should have known that is a violation of a clearly established, constitutionally protected right of which a reasonable officer would have known. which means they not gonna get immunity. So if that happens to you, the only thing that you need to allege are those facts. That's it. The judge is gonna look at those facts, and the judge is gonna say, well, based on these facts, this officer is not entitled to qualified immunity right now. So we're gonna set this case over, and we're gonna go through discovery, and we'll give them about, depending on how complex the case is, you might get about 6 to 8 months to maybe a year to go through discovery. Would a reasonable officer just come to your house without any facts justifying it whatsoever, forces her or his way into your home over your objection, and arrest you just because they want to? No, a reasonable officer would not do that. Because a reasonable officer knows, or should have known, that that is a violation of a clearly established, constitutionally protected right of which a reasonable officer would have known about. And they are not going to get immunity. They supposed to go to jail for doing shit like that. A reasonable officer would not do that. So let me ask y'all something. Would a reasonable officer detain you for simply refusing to provide her or him your ID without any facts to justify why she or he is detaining you? No, a reasonable officer would not do that, because a reasonable officer knows, or should have known, that that is a violation of a clearly established, constitutionally protected right of which a reasonable officer would have known. And they are not going to get immunity when they do that shit. And that's all you have to, that's all. If that happened to you, that's all you need to allege in your complaint. That's it. With a reasonable officer, let's say that this officer lawfully detained you. So you're in a lawful detention right now, and they just wanted to ID you, because we just gonna say it's a traffic stop or whatever. And we're not gonna argue the right to travel or anything like that. We just gonna say this is a traffic stop. They stopped you. They ask you for your ID. You give them your ID or whatever, and they go back, blah blah blah. And after they give you the ticket and run your name, whatever, you say you fucking pig or something like that, or you say asshole or something like that. Would a reasonable officer so-called orders you, because that wouldn't be an order because you wouldn't be no longer lawfully detained, but would a reasonable officer arrest you for saying you fucking pig or you asshole or something like that, for giving you a traffic ticket? Would a reasonable officer do that? No, a reasonable officer would not do that, because that is the violation of a clearly established, constitutionally protected right of which a reasonable officer would have known or should have known about. And if they arrest you for that and take you to jail and all this shit, whatever, if they do that, they are not going to get immunity for that. Because calling somebody an asshole or calling somebody a fucking pig is not a crime. They'll say it's disorderly conduct or some shit like that. That's what they like to say. But that is not disorderly conduct. Disorderly conduct has been interpreted to only mean like fighting words that could be construed to provoke a breach of the peace. And I got cases on that, if y'all ever want to see it. So no, a reasonable officer would not do that. A reasonable officer would not do that. Would a reasonable officer just walk up to you and just say, hey man, don't go nowhere, I want to talk to you? And you just walk off, and they grab you, and they jump on top of you or whatever, and they take you to jail for failure to obey, resisting. No, because in order for you to get charged with failure to obey, you have to be lawfully detained. So they're going to assault you and battery you. That's false and that's everything. A reasonable officer would not do that, because that is the violation of a clearly established, constitutionally protected right of which a reasonable officer would have known or should have known. And they're going to lose on qualified immunity grounds. They're gonna settle that case. Let me go back here and let me explain something else to y'all. So in this motion for summary judgment, they're arguing their facts of the case, saying that they are entitled to immunity because this, and this, and this, and this. And I'm saying no, they're not entitled to immunity because this, and this. So when you have these facts, we're arguing over about what actually happened. So anytime that you have that situation before the court, the judge cannot apply the law to the facts of the case because the judge doesn't know what happened. So that would go to the jury to decide. Your story would go to the jury to decide, and their story would go to the jury for them to decide. And the jury would say they're going to pick the story who they think is the truth based on the facts and circumstances of this case. And they're going to decide if these officers are entitled to immunity or not, or if you are entitled to whatever you're asking for or not. That's what they're going to do. Always allege facts. Be very detailed, but brief as possible with your facts. And that's all you got to do. That is all you have to do. If y'all need any of these cases, if you're in Alabama, Georgia, Florida, or pretty much anywhere, because I have some federal cases in here too, like these cases right here. I have some federal cases in here. So if you need any of these cases or whatever, just let me know. Because I got tons of them. I know how to do the research and I know how to frame my arguments. This stuff ain't hard, man. Everything that you're arguing in your case, all of your inferences or your conclusions need to be based on facts of the case. And your conclusions need to be reasonable based on the facts of the case. Like, for example, like if you walked outside and looked and it was just dry as hell outside and the sun is out, can you reasonably conclude that it's raining based on that? Hell no, you can't, because you see the sun out, it's dry as hell, the wind is blowing, it's a beautiful day. No, it's not raining outside. That's not a reasonable conclusion. You see what I'm saying? Shit ain't hard, man. This word right here, a reasonable person, and this word reasonable, that you need to use that word every goddamn way. Once you figure out how to use it, you're not gonna stop using it, because I know how to use it. I assess the facts of the case, and I make a conclusion based on those facts, and that conclusion or those inferences would be reasonable based on the facts. So no, a reasonable officer would not have done what these idiots did in my case. No. That'll be the end of this video, man. Hopefully this gave y'all some more clarity on what a reasonable person is, a reasonable officer, so on and so forth like that, because you need to know what those words are. Reasonable person, reasonable officer, just reasonable. The reason why they use that word reasonable is because it's used in the Fourth Amendment. Well, unreasonable is used in the Fourth Amendment, so they use the opposite of unreasonable, which is reasonable. So if they act reasonable, if they act reasonably based on the facts and circumstances of the case, they'll get immunity. Because the Fourth Amendment only prohibits unreasonable searches and seizures, not reasonable searches and seizures. Y'all see what I'm saying? Simple. Simple, simple, simple. So, you bold, courageous motherfuckers, study, and get this shit down pat. Because I know you can do it. That'll be the end of this video. Supreme Litigant is out. Peace.